Hello, this is a presentation from Family First Legal, mediation and collaborative law firm. This presentation will be a quick tip on how to use evidence in court. This is not intended as a legal consultation or a legal advice. This is only for educational purposes. In an earlier module, I went over the types of evidence and I will briefly go over them here. But if you want to know more about these types of evidence, then please check out our quick tips on the types of evidence. The four types of evidence are documentary, testamentary, digital, and tangible. So briefly, documentary deals with the documents that you will have. Testamentary deals with witnesses and what they will testify to. Digital deals with discovery or evidence that will be on a digital device or a digital resource. Tangible deals with things that you're going to bring to court, which the court can look at and touch that are related to the case. So there are three main things that you want to do with evidence. Once you have that evidence in court, you're going to want to do three things. The first thing is going to be to corroborate. Corroboration, or to corroborate, simply means I'm going to use this evidence to support my claim. In other words, everything that I've claimed in my pleadings, I am going to support it with some piece of evidence, whether it's a tangible piece of evidence, a document, or whether it's something someone testifies to, or whether it's something on a digital device. So whatever you're claiming, you need to make sure you have some sort of evidence, and generally I would suggest no less than two pieces of evidence that supports every claim that you have. If you have less than two pieces of evidence, then you're leaving yourself open for the other party to come in and claim that that evidence is not sufficient, or for the court to find that it's not sufficient for the court to make a finding. So I would say no less than two pieces of evidence for every claim that you're trying to support. So once you're able to support your claim, you're showing the court that it's more likely than not that that the thing you're saying is actually true and that you actually told the truth. So your testimony might be one way in which you support the claim. You're going to testify to the things that are in your claims or in your pleadings. But then you need something or someone else to support what you're testifying to. That might be a video corroboration. That might be another witness corroborating what you're saying. That might be a document that shows exactly what you're saying. So whatever you're doing, however you're testifying or however you're presenting evidence, make sure you're doing it in multiple ways and at least two different types of evidence or two different pieces of evidence that supports every single claim that you're making. If you can't support your claim, then you may want to consider that that claim isn't one that you want to fight particularly hard, or you may want to change or amend your pleadings to align with what evidence you have. The next thing you're going to want to do is to use your evidence to impeach. Oh no, you got me. I lied. You will probably never hear a witness on the stand say that they lied, but you might hear them say, I forgot, I can't recall. Oh, I'm sorry, I didn't remember that. And usually that happens because you're impeaching them. They've said something on the stand, they're testifying on behalf of the other party, or it's the other party who's testifying, and they've said something that's not true, and you've now brought in a piece of evidence to show them that it's not true. So that will look like this. The person's claiming that they took the child to medical appointments, and they didn't take them to medical appointments. And the way that you can prove that is you have medical records from the doctor's office saying that the child missed appointments every single time they were with the other party. Those types of records can be helpful in impeaching the other party. So when they say, I took the child to the doctor every single time, those records show that that's not true, and helps the court to see that witness as an untruthful person. Now, the court could look at an impeachment piece of evidence as the person was untruthful on this particular issue that you've impeached them on, but when you impeach someone more than once, the court can assume that this person's testimony might be wholly untruthful, which is very beneficial, because if the court sees someone as untruthful, the court might not believe anything they say unless there's serious corroborating evidence on their side. So impeachment is a good thing, and it's the only way that you can prove that someone is lying. The last way you want to use evidence, or one of the last ways you want to use evidence, is to refresh. Oh man, I forgot everything. When you get on the stand it is very possible that everything's going to slip your mind because you are nervous. You've never been on the stand, or you're rarely on the stand, and this is not something you do in your everyday life. So, one of the things that you can do is, when you know there's things that you must testify to, you can make sure you have documentary evidence or a diary that you've kept that you can have there in the courtroom with you, not on the stand. You can only use this type of evidence when necessary to refresh your memory. So let's say, for instance, you are trying to recall child support numbers, the amount of child support either that you paid to the other party, or the amount of child support the other party has failed to pay to you, but you can't remember what was paid in what month, but you have a diary that you've kept. So you may say, I don't remember, but I have a document here with me that I kept in real time whenever it was happening that will refresh my memory. And you can ask the court for permission to look at that document, or your attorney will ask the court for permission to show you that document to refresh your memory. When you're using documentary evidence to refresh memory, you can't read from the document, but you can take your time and review the document thoroughly. And you can review it more than once if you need to. And then you will respond without reading the document based on your recollection about what you just read. So in March, I paid $600, and it seems that in April, I paid another $600. And then in May, I paid $1,000, which was more than what I had to pay, even though the other party's claiming that I only paid $400. So now your memory is refreshed, and you're sure that your testimony that you're giving is the true testimony that you wanted to give, and that you haven't left out anything that's important. So make sure that if there's something that, particularly numbers, are something that I notice people struggle with, but if there's something that you're thinking you might forget to say, then make sure you have the documentary proof or evidence that you can use to refresh your memory, or that your attorney can use to refresh your memory. Now, this has been a presentation by Family First Legal Mediation and Collaborative Law Firm to help you understand how to use evidence in court. Hope this was very helpful to you. If you would like more information on this topic, or you would like to have a consultation with us, please reach out to us. You can contact us through our website, www.fflmd.com, or reach out to us on social media at Family First Legal. Thank you.